Intellectual property, or IP, is an umbrella term for trademarks, copyrights, and patents. Sometimes, the protections offered by this trinity can overlap, but their differences are mostly clear. Trademarks. Trademark law protects brand names, slogans, and logos. Walmart and McDonald's are not just the bastions of American hegemony, they are, in name and style, the intellectual properties of corporate America. If you too boldly dream of one day owning your very own business that you've driven to success on the backs of minimum wage workers whose living incomes are subsidized by the federal government, it is crucial that you do not follow in the infringing footsteps of Mr. McDowell.
They're McDonald's. I'm McDowell's. Huh? They got the golden arches. Mine is the golden arcs. Now see, they got the Big Mac, I got the Big Mick. We both got 2 all-beef patties, special sauce, lettuce, cheese, pickles, and onions. But they use a sesame seed bun. My buns have no seeds.
Copyrights. Copyright protects literature and audiovisuals, including your favorite films, photos, songs, and musical works. This area of the law may come into play when people illegally download pornography. There are criminal laws in place that make it illegal for children under 18 to be exposed to pornography. But there are also copyright laws in place that prohibit the viewing of pornography if it is obtained by illegal means, irrespective of age, i.e., pirated rather than paid for. Patents. Finally, patent law protects inventions like Viagra and designs like the thong diaper. However, if you're like Colonel Sanders or Robert Woodruff, you may wish to withhold your herbs and spices recipe as a trade secret by guarding it in a vault. As long as your trade secret is not revealed to the general public, and as long as it isn't subject to inevitable independent discovery by equally creative competition, you can forego revealing it publicly in an application for the limited 20-year duration of patent protection. Thus, with patent law, one must consider the trade-off between maintaining a trade secret versus coming out of the closet with a patent application. Formally registering your copyright, trademark, or patent. As copyright is a form of protection grounded in the U.S. Constitution, it is granted for original works of authorship fixed in a tangible medium of expression. Copyright covers both published and unpublished works, but you can register your work with the Copyright Office for a presumption of validity and entitlement to statutory damages and attorney fees in federal court. Likewise, trademarks and patents must be registered with the United States Patent and Trademark Office, whereas a trademark is only granted if you're actively using the mark in commerce. A patent can be granted so long as it does not violate existing prior art. So there you have it. Intellectual property is property of the intellect. Property that is creative, albeit, contrary to the implications of the phrase, one need not exercise much intellect to get the protections of intellectual property law. Speaking at least in the context of copyright law, the Supreme Court once said, "Originality requires a modicum of creativity." Now get out there, make an invention, create a brand, draw something, film something, and make your Uncle Sam proud. All statements here made are absolute and utter nonsense. Attorney not responsible for damage to your life.